Which British citizenship application applies to you? One of the most common reasons British citizenship applications tend to be refused is because people apply under the wrong route. It is not a single process, and many people often assume that applying for British citizenship is just a single process. However, it's oftentimes a multi-stage process that needs to be followed, and it's of absolutely key importance that from the beginning of undertaking an application, it is understood exactly which route one would take and how you would go about implementing all the evidence required to satisfy that route and obtain your British citizenship. Automatic acquisition oftentimes happen, for example, if one is born in the United Kingdom to British parents or parents with indefinite leave to remain, or if one is born abroad to parents who naturalized in the United Kingdom or who were born in the United Kingdom. Automatic acquisition is very heavily dependent on the laws in force at the time of an applicant's birth and changes very frequently. And it's important to take very careful review of the law before making an application to make sure that the application is made on the correct legal route and the relevant law that actually applies to one's own specific case. Naturalisation is often the most common route that migrants would use in order to obtain British citizenship in the United Kingdom. It requires, generally speaking, a period of residency to have been undertaken in the United Kingdom, whereafter one can apply to be naturalised. The requirements for naturalisation can be quite strict, and clients often fall foul of various requirements such as the good character requirement, which is especially big focus lately from the government, as well as things like the travel requirements, not having the correct referees to support their application, and oftentimes simply using a outdated application form. Naturalisation applications is the capstone of many people's immigration journey and should not be undertaken lightly. Registration can be a simple and at the same time a very complex route. Registration applications generally apply to children, especially children born abroad, to parents with UK ties, and also to applicants who were disadvantaged through previous historic gender discrimination and historic laws that discriminated in various categories, really, where an adult can make an application for late registration. These applications can be genuinely complex, but it also provides an avenue, especially after the newest rule changes in 2022, where applicants who couldn't previously apply can now apply, and oftentimes applicants who don't understand or believe that they can apply upon careful consideration, turns out they can apply. It is genuinely advised to take legal advice on the more complicated routes as far as registration is concerned, and it could often lead to great success if undertaken correctly. In practice, we often notice that applications have failed where the clients do have a claim for registration, naturalisation, whatever it might be on their particular facts, but the application failed because the clients applied under the wrong route, they could have used the wrong piece of legislation, or the form could just be outdated. It's very important to take note of the small details, the good character requirements, the travel restrictions, and applying the relevant law in order to ensure that what could be the most important immigration application an applicant makes is successful. In closing, if you are considering a British citizenship application, albeit by naturalisation, registration, or just applying directly for a British passport, it really is important to take legal advice, do your research properly, don't take any chances. And if there is a claim, then generally speaking, that claim really should be successful if the application is indeed tackled properly.